After the break, we continue the special joint meeting. Please invite the candidate to the position of the judge at the Hague, Kytsyuk Viktoriia Serhiyivna.
Добрий день, сідайте, будь ласка.
Good afternoon. Please be seated.
Розглядається питання щодо відповідності кандидата
We're
на посаду
considering the issue of compliance of the judge to the position of the judge at the Hague, Kytsyuk Viktoriia Serhiyivna by the Part 4, Article 8 on the law of the Hague. The members of the PCIe members are present here. Names follow. Chaired by Robert Brookhuizen.
Гаранскієне дистанційно, Джон Джей О'Саліван і Джесіка Лот Томпсон. Також присутні члени Вищої кваліфкомісії
Also,
суддів
the
України.
HQCJ members are present. Names follow.
Віталій Гасилюк зараз доєднається до нас. Ярослав
Vitaly Haseluk is joining us shortly.
Надія Кобецька, Олег Колюш, Ігор Кушнір, Руслан Мельник, Олексій Амелян також доєднається пізніше. Роман Сабадаш.
Alexey Amelian will also join us later.
Галина Шевчук. Амеляна не буде.
Amelian will be absent.
То за інформацією Амелян.
Then, according to the information available, Amelian will be absent due to his service.
Вікторія Сергіївна, чи зрозуміли вам склад комісії?
Viktoriia Serhiyivna, is the composition of the commission clear to you? Yes, I have no motion recusals. I haven't asked you about recusals yet. Your rights are to demand recusals from the commission members, submit motions, express your opinions and objections, appeal the commission's decision. In this special joint meeting, no new materials are being considered from the candidate. All the materials have been submitted by the candidate in the required deadlines. If there are circumstances that can affect the status of the candidate, then at the approval of at least 3 members from the HQCJ and of the PCIe, a decision can be voted to consider new materials. Are your rights clear to you? Yes, they are. Now I'm asking you, do you have any recusals or motions? No motions and no recusals. Thank you. Then we can continue the session. Viktoriia Serhiyivna, I know Viktoriia Serhiyivna in professional field. We worked in the same working group to develop a draft law in 2017-2018. That law was adopted later by the parliament. We also participated in court sessions too. We don't have, we're not on friendly terms. We have maintained professional relations. Any questions to Ludmila? No questions? And you? No recusals, no motions, no questions. Okay. So the rapporteur is Melnik Ruslan Ivanovich. You have the floor. Thank you.
Отже, Kytsyuk Viktoriia Serhiyivna.
So, Kytsyuk Viktoriia Serhiyivna, in 2023, graduated from, in 2003, graduated from National Law Academy named after Yaroslav Mudro, earned a degree in law, has no academic degree. From 2003 to 2011, she worked as a legal consult at LLC Schitagro Contract. Based on the decision of the Kharkiv Oblast Qualification Disciplinary Commission of the bar, she received her attorney license that was seized, and her attorney activities were seized. in 2012, following the president's order from 2012, Viktoriia Kytsyuk was appointed to the position of the judge at Kirovsk District Court in Donetsk for 5 years. The judge took oath in 2012 by the order of the President of Ukraine. As of 2013, Viktoriia Kytsyuk was transferred to the position of judge of the Solomensk District Court. By the decision of the panel of commission from 2018, the judge from Solomensky District Court, Kytsyuk Viktoriia, was believed to be compliant by the order of the President of Ukraine as of 2018. Kytsyuk Viktoriia was appointed to the position of the judge at the Solomensk District Court without deadline, without a term. Viktoriia Kytsyuk has no less than 5 years of professional experience at the position of judge and speaks Ukrainian as fluently. Thank you. Now over to the chair of the PCIe, Robert Brookhuizen.
Thank you, Mr. Chair. Your rapporteur will be Mary Butler, and she's on the screen. Mary, say hello.
So,
Please, over to you, Mary.
okay. Can you hear me?
Yeah.
Great.
Yes.
Yes.
So, Ms. Kytsyuk, thank you for your cooperation in this important process. I think you have heard who my colleagues are on the PCIe. But as you know, I'm Mary Butler. I'm a prosecutor in the United States. I want you to understand that in response to some questions that we provided you in writing, we did receive and review your answers. Some of the questions that I will ask you today will call upon you to repeat some of the information you provided. And we're doing this in the interest of transparency because there are people in the public who will be interested to know that we have considered the questions that we asked you. So I want to start first with a question about how you came to the Solomansky court in Kyiv. And I am not asking you why you wanted to transfer, but rather how the process happened. I'm aware that under the law on the judiciary and the status of judges in force in 2012 and 2013, under Article 73, a transfer to a judicial position in another court should be carried out through a competition. And it's my understanding that in April of 2013, you submitted an application for transfer to the Solomiansky District Court of Kyiv. And about 2 weeks after submitting the application, you received a recommendation for transfer. And my question is, was there in fact a competition in which you participated in order to receive this important transfer?
Так, дійсно, письмові відповіді
Yes,
надала
indeed.
більш
I have provided my written answers in more detail.
взяти ще інший
Now,
період, щоб надати
I could take a different period
на це питання,
make,
було зрозуміло.
in order to answer your question,
Мною була подана така заява.
so that you understand why I submitted that application in April 2013. While working as an attorney, since I got my attorney license,
But my question was not why you wanted to transfer, but how the transfer was accomplished. I'm sorry.
Я зрозуміла. Добре. Коли була
Okay, that is
призначена
clear.
на посаду
So when I was
судді в
appointed
Кіровському
to the
районі
position of the
міста
judge in the
Донецька,
Kytsyuk
це 31
District
липня
Court,
2012 року,
July
моя
31st,
професійна кар'єра,
2012,
професійна діяльність,
when I was
щоб
appointed.
пояснити на питання
So in order to
переведення
answer
мого
your
подальшої
question
участі в
about
конкурсі,
my
я все
transfer,
ж таки хотіла б вам
I would like to
моменти мого особистого життя також
go back
розповісти
to
в
some episodes of my
допустимих
personal
межах, тому
life
що саме
within
особисте
the
життя
allowed
стало
limits, because
підставою
my
зміни
personal
моєї
life
позиції напрямку і
generated
зміни
a
міста, куди я
circumstance for
подала
me
заяву
to
на
change
переведення.
my direction and
Призначившись
to
на
submit my
посаду судді
application.
міста
So after I was
Донецьк,
appointed
Sorry.
я
as a
I'm sorry.
judge in Donetsk,
I'm sorry, I understand why you wanted to transfer. The relevant, I'm sorry, I understand why you wanted to transfer. I've read about your personal circumstances. The question is how you accomplished the transfer. Is it your position that the competition rules were overcome by some other necessity, or are you saying that you did participate in a competitive process?
Питання письмове, яке було мною отримано, воно полягало
so
в
the
тому, яким
written
чином
question
я
that I got
дізналася про наявність
was
вільної
about how
вакансії
I
в
learned
Солом'янському
about
районному суді,
vacancies in
оскільки на
Solomensk District
сьогоднішній
Court.
день відстежити такі
Currently,
оголошення вбачається неможливим.
it is impossible to find such announcements of vacancies. While trying to find such vacancies at the website of the VKKS, there is only some information, HQCJ website, correction. This information made available after 2016. And the decision that was submitted, that was made after my application, is not in public domain. It's only in my dossier. How did I learn about the vacancies? But some tragic circumstances occurred in my personal life, of which I reported in writing. And those were the circumstances that became the drivers to shift my professional direction. It's very good that I have become a judge because I have dreamt of this position, but at any rate, I had another dream that I also had as a woman. And in order to make this dream come true, we talked to my husband at the time about our common life. He didn't want to come back to Kharkiv. He didn't want me to be transferred to Donetsk. And because of that, just like the first time when I was transferred to Donetsk, I took decision on my own to move my career forward. On the internet, I started looking for vacancies available in open domain in Kyiv, vacancies for judges. At that time, what I managed to find was that in Kyiv, there were changes because of dismissals of judges. There were vacancies because of that. And also, judges were transferred. In March, by the order of the President of Ukraine, there were dismissals in Solomensk District Court. 2 judges were dismissed, and this is a public information available, still available. Before that, information is unavailable, and therefore the HQCJ decisions were unavailable either. Then there were also, later on, there appeared 4 more vacancies in Solomensk District Court because 2 judges were transferred to other courts in other cities. And this is how I made a decision to submit my application. In my application, I needed to substantiate my motivation to submit this application in order not to disclose my personal reasons that were the drivers of that decision to be with my husband. I declared that my motivation was that I wanted to work where my husband worked. And regarding the competition, in the public domain, currently, there is an announcement, and I sent it to you, announcement of the results of the meeting held with my participation inclusive, where the issue of my transfer was decided. Regarding Solomensky District Court, so in general, 4 judges were candidates to positions in Solomensky District Court. And in the decision related to my candidacy, there were no references to any other judges. But if you take a look at the announcement as of April 2013, you can see that in fact there are 4 candidacies to that court. Also on that day, an issue of transfer of other judges was considered. Some got refusals, others got approvals.
Sorry, but I don't think that you have answered the question by pointing out there were vacancies. The question is whether you obtained this position through a competitive process. And I believe that your written answer to that question was, you think so because somebody asked you about your professional competence. Is that your answer?
Відповідно до рішення Вищої кваліфікаційної
According to
комісії,
the decision of the High Qualification Commission of Judges of 15th of April 2013, there is a reference to the fact that this procedure was organized according to the law of Ukraine on the judiciary and status of judges. As of January that year, and in that decision, it is indicated that the results of the checks were analyzed and the interview was organized to come to make an assessment on moral qualities and Article 71 of the law on judiciary and status of judges also included a norm that the High Qualification Commission of Judges of Ukraine during such a conversation with the candidate can take into account the results of the previous assessment. Considering that as I was appointed to the position of a judge in Kirov District Court, I scored a certain score, so I think that in that second selection, these results were taken into account.
Well, I'm sorry, maybe there's a translation issue, but as I understand it, you are now saying there were 4 vacancies, there were 4 candidates, and all 4 were appointed to the Solomonsky court with you. Is that your statement?
Yes, yes. There were no other candidates to this specific court.
Yeah. As some may know, you previously applied to be a judge of the High Anti-Corruption Court, and the High Qualification Commission of Judges and the Public Council of International Experts, in an opinion dated January 23rd, 2019, found that you did not meet the criteria set out in Article 8 of the Law of Ukraine on the High Anti-Corruption Court. The decision, which some of us have reviewed in writing and others by watching the videotapes of the interview process, focused on two particular incidents. There were other questions asked, but two main incidents, which I want to discuss with you today. And one has to do with Facebook posting, and I appreciate that this happened in December of 2017, that you posted on your Facebook page links to articles with some of your own additional comments, and the post which you reposted was from the attorney of a defendant whose case you were participating in considering in criminal proceedings in the Solomonsky court. In particular, the articles that you reposted contained criticism of the role of NABU in preparing the case for trial, that is the case that you presided on, as well as criticism of the concept of establishing an anti-corruption court in light of that criminal proceeding. And I'm asking you about this because I want to hear whether you think there are other facts or arguments related to the reasoning that was set out in the decision made in connection with your application in 2019, which in your opinion should cause us to reassess or take into account when we consider that prior decision in your current application. I realize that was a long question. If you want me to start over, I'm happy to.
Ні, дякую, я зрозуміла.
No, thank you. I understood the question. Indeed, I am here because I think that decision, or rather the circumstances that were grounds of that decision, could be reassessed. As I know the practice of the High Chamber of the Supreme Court, which considered the previous candidates, the High Chamber came to a conclusion that in the current legislation there are no definitions of integrity, ethical conduct. These are all subjective criteria that the members of the Public Council of International Experts and members of High Qualification Commission of Judges assess subjectively during the interviews. I think that the questions that I was asked back in 2019 that I had to answer, well, I wasn't convincing in my answers enough to prove my opinion. Now I would like to inform of the two circumstances that were grounds of that decision. So first, it was related to Facebook posts. It was mentioned that the candidate posted twice on her Facebook page certain articles with her own comments. I sent to you the screenshot of the Facebook page with these two posts for March 2017 without my comment. It was just the post I shared. And the second post was for December 2017 with my comment in the title, and it was judiciary in Ukraine, how the high-profile cases are perceived by the public.
На що звернути
Uh,
увагу?
I
На те, яким
decided to share these posts to draw attention to how certain criminal proceedings were examined in my court, in our court. I would like to add that I personally, since May 2017, didn't get any criminal proceedings because in July 2017, my term expired as on the position of a judge, and 2 months prior to that, the allocation was stopped. I considered two trial petitions at the pre-trial investigation stage, and as this proceedings was considered when the first petition came to Solomensky court, was related to the to applying such a measure as detention. Why did I share this article of a well-known attorney on my own page? I ask you to assess it together with the second post because they are interlinked. The second post is related to the announcement of the head of the court, and it's about the examination of criminal proceedings and petitions at this stage of pre-trial investigation. And when the petition appeared on the detention, this petition was not considered in during the first day. It was postponed to the second day, and a lot of people came to the court, a huge number of people. The premises were blocked. A lot of members of parliament came, and the activities of the court were not blocked. We kept working, but it was with this huge accumulation of people around the premises. Unfortunately, we know cases when the parties abuse their rights, and in that case, it's my conviction that when the term of the period of detention was coming to an end, the investigative judge was recused. It was on a weekend, and it should be noted that the court functions from Monday to Friday, and the Assembly of Judges decides who will be on duty out of the judges, but it was Sunday. And since there was a recuse, since the judge was recused, and it was already Sunday, it was announced that the court session would be postponed as to the second post because it's related. A lot of people came at the address of residence of the head of Solomensky court, and they started shouting and demanding that the consideration of the recusal is made. Some MPs expressed their disagreement with such actions. In their opinion, it was lack of actions by the head of the court, stating that it was the responsibility of the head of the court that the recusal was not considered, and because it was not actually provided for by the then legislation, that such petition is handled And the activities of the court were blocked, and later the MPs filed the claim to the National Anti-Corruption Bureau. And all of these circumstances showed that this behavior was unacceptable, and the court could not function at such environment. Today, I agree that such posts, Facebook posts, and the title in Russian, why NABU puts pressure on the court, can be indeed perceived by my followers, external observers, as me confirming what I share on Facebook. But after that meeting, and currently I remained on Facebook. I haven't blocked my page. I do not think it's right when judges hide after difficult situation, because we are not specialists in communications, and just recently the judges started communicating with the society, and we have to learn how to do that. And currently the conclusion I reached is if I want to inform my followers, readers, or society of something through my own Facebook page, and if I write a post, I need to provide full comments from myself in the title of the post, so that it's not perceived that that I confirm every word in the article I share, or that I support the title of the article. You all know that the media often chooses the title which doesn't correspond to the content of an article.
Let me just ask one follow-up question. Are you saying that when you posted the Facebook posts which the previous PCIe considered, that you were posting articles of the defense attorney from a case that you had presided in, but you were no longer presiding over? Is that what you're trying to say?
Так, я розглядала, здається, одно чи два
Yes, I considered one or two petitions in March, April, not later. But starting from May, the automatic allocation was stopped for me, and in July, I didn't have a right to consider whatsoever. And when I was examining these petitions, I didn't have the said attorney, and it seems to me that he started representing that person much later.
Okay, but do I also understand you to say that, looking back, you think that it was a mistake to have posted as you did, and that you've learned from your mistake? Is that what I understand you to be saying?
Так, звісно, потрібно
Yes, of
більш
course.
інформативно
We should
Якщо я звертаю увагу, пишу якусь публікацію,
indicate our position in greater details. If I share an article, someone's article, and I do not agree with every specific word, we have to indicate why I chose to share a certain article, and we have to be very careful when we share articles where titles are different from the content.
Okay, and another issue which the prior PCIe and HQCJ focused on had to do with the issuance of an order giving a NABU detective access to documents containing bank secrecy. I'm sure you recall this area of questioning. Yes? You recall? Yeah. So what the HQCJ and PCIe from the recording that I observed, they were particularly concerned that you had granted a NABU detective access to bank records, and then subsequently, maybe 2 to 3 weeks later, without summoning or notifying NABU or the SOP, you adopted a ruling narrowing the scope of access at the bank's request, but you did not notify NABU or SOP of an opportunity to come and be heard on this issue. Do you recall that?
Так, другою підставою, якою було
Yes,
визнано мене
the second reason of dismissing me as a candidate in 2019 was the criterion of professional competence. I would like to draw attention to the fact that the reason for considering my candidacy during the joint meeting was the information from the special information note, and in that note there were no questions about that specific ruling. And when I started getting questions about that ruling during the meeting, and it was 2 years after the ruling was issued, of course, I was not capable to answer every specific question. There was a break announced. I found that file, but the question was about the this temporary access to the banking document, but I didn't have time to clarify all the other details. Of course, after the interview, I studied the circumstances of the case. I recalled some details, and now I would like to give you provide explanations. On Friday, I sent additional explanation, and to be able to understand the answer, I also provided the first ruling on temporary access, the ruling to correct the mistake, and the decision of the appeal instance. I would like to first look at the first ruling from December 2016 on correction of a mistake. In the descriptive part of the ruling, it is stated that the detective was present. If you look at the abstract 22 of the ruling, it says that after I heard the detective who didn't insist on the access to all the documents, it shows that as I was analyzing the materials of the case after the statement of the detective himself informed what specific documents and things he was asking access to. And as I was working on the full text of the ruling, there was a mistake made stating that the position of the detective was not taken into account. Later, I also read that only the first page of the ruling was provided, but back then the question was only about the date. And the date with the court stamp is on the first page. That's why only the first page was submitted to the public council. Yes, we didn't wait for the note that the other initiator of the petition knows about the time and place of consideration. Due to that, the Court of Appeal cancelled this ruling, and there was, and I want to draw attention to the ruling of the Court of Appeal, where the motives of the prosecutor were explained, due to which he asked to cancel that first ruling. There were two grounds: the procedural one, that the detective wasn't aware, and the second ground was that in his opinion, the text of previous ruling was shortened, but the Court of Appeal didn't make his decision based on the second motive, but only concluded that the procedural element was violated. Please be more concise in your answers. Excuse me. Please.
So if I understand you, in something that you sent us on Friday, which I apologize, I haven't been able to find, you're saying that the Court of Appeals only questioned the procedure you followed. Is that what you're saying? Yeah.
Right.
Okay. But that was the basis for the PCIE's criticism, that you narrowed the order without giving the NABU or the SOP the chance to appear before you and try to persuade you to give them what they had fully asked for. Right?
Так, це була підстава.
Yes, it was
Це була підстава для
the grounds to state that I didn't comply with the criterion of professional competence. But currently, as I got familiarized myself with the materials of the meeting, as I watched the interview, it became clear. Unfortunately, I do not understand why you do not have what I sent on Friday. If it's necessary, we will of course consider it, because the first ruling on temporary access to documents and things is in the register. That's something I refer to, that the detective was present, and in the abstract 2022,
it was when you changed it that you didn't give them an opportunity. It was when you changed it to narrow it that you didn't give NABU an opportunity to appear, to make arguments in support of its original request. So it was a procedural violation. Is that what we're agreeing on?
Так,
Okay, let me turn.
yes.
Sorry.
Можна? За наслідками даного засідання, аналізу
Upon the results of the meeting and after analyzing this case, I came to the conclusion that the Code of Criminal Procedure of Ukraine states that to consider documents, the investigative judges have a very limited time frame from 3 to 5 days. So currently this situation is resolved because there is an electronic exchange of messages between the court and different bodies, as well as between the court and the detectives. Before that, it was happening through a post service, and there was a delivery serviceman who had to deliver all the documents. And I'm not saying that it's not my responsibility. I'm not just explaining such a behavior. And the notification that the prosecutor's office received the notification about the time and place of consideration of such a document didn't come back to the court. And for the future, of course, I agree that the established timeframes cannot be violated, but there are different periods, and certain court sessions can be postponed to wait and get confirmation that the parties involved in the case are well informed, and they will then decide whether they come to the court session or not.
So I'm not aware that you gave NABU the chance to appear before you changed your ruling. They got the notice that you changed your ruling after you'd been contacted by the bank sometime later than the bank got the order. But they were not given the opportunity to object to your changing the order. Those are still the facts, right?
Справа в тому, що вони дійсно не знали про розгляд даного.
Indeed, they didn't know about the consideration of such a request because there was no confirmation that they received the notice. But later, it was not an obstacle to submit a claim to the Court of Appeal, and the Court of Appeal cancelled the ruling due to procedural motives. And it's my conviction that cancelling a court ruling is not a guilt of a court. That's why we have the cassation instance and the instance of appeal. In my opinion, we should assess this situation and my act from the point of view whether there was some influence on me, some pressure on me during such a decision, and or whether these acts were due to the fact that I didn't make sure that one of the parties involved in the case was informed. I read the letter sent to the Commission from NABU, where they state what they knew and indicate the circumstances they are aware of, and provide information that after that ruling back in 2017, there were a lot of investigative and procedural acts undertaken, the searches, the seizures, and a lot of things were seized within that criminal proceedings, but there is no mentioning of Kytsyuk judge in these documents. And I'm sure that if the pre-trial investigation body found that I was somehow interested in taking this specific decision, which would be contrary to the then legislation, I'm sure that the NABU would properly react, but they were acting in a different way. They submitted that ruling for the joint consideration.
Now I want to move to an incident that happened in 2017 in which you were detained by police officers with the use of force in connection with an alleged traffic violation. And as I think you know, the police officers were wearing body cameras on their as part of their equipment, and there was a lot of public awareness of this controversy between you and the patrol police. And in particular, my specific question is whether or not you agree that the video shows that the police officer asked you to present documents establishing your identity and your legal ability to drive a car. And although you were sitting in the driver's seat of the vehicle, you said that you did not need to provide these documents, that you were not the driver. And I want to ask you whether, taking into account your status as a judge and the need to always appear to be complying with the law and not engaging in unnecessary conflict with law enforcement, whether you believe that you acted in accordance with judicial ethics standards during this episode.
Дійсно, в даному запитанні є посилання на статтю.
Indeed, there is a reference to the Censornet article, and the video is available on the Facebook page of the head of Patrol Police Department with the comments. In that post, Zhukov indicates that it's only a fragment of a video, and I think it's wrong to give an assessment to the events and come to a conclusion based on the fragment of the video. If we follow the link, we'll see that there is no author, and the ChatGPT says that Censornet is a website of emotional use. I would like to draw your attention to the decisions we have. We have the decision of the High Council of Justice and the decision of the judge. What happened on that day? After the working day, I came to my car to go home. It was winter, it was slippery and dark. After I understood that I could not start moving because there were other cars parked in front of me and behind me, I decided to call someone I knew for this person to come and help me. At that time, a man knocked the window of the car. I saw that it was the patrol policeman, and next to him, the road which was available for vehicle movement, there was a patrol vehicle. The officer said that I had to leave that parking space. I informed him that it was impossible because the car was blocked. After that, he came to his patrol car. I decided to get outside and wait for the husband for him to come and help me. During that time, strange things started happening, as I thought. Other men came and started shouting, "Leave the place." Other citizens started assembling and expressing their opinions about me, and these were very arrogant expressions to the judge. And when I started going in the direction of the court, the patrol policeman drove back. One patrol policeman approached me once again and started preventing me from going back to the court and started asking for my documents. And I was not driving that vehicle at that moment, and the situation in general, in my opinion, showed that something unclear was happening. The patrol policeman demanded the document, but I answered that I was not a driver because at that specific point I was not driving a vehicle. There is this general rule that the court knows the laws. I understand that back then the current legislation didn't allow, according to the law on national police, to approach any person and start without explaining why, demanding to show the identification documents. After that, everything happened very quickly. I was handcuffed and in the patrol police vehicle. The only thing I managed to do was to call the colleague for her to get outside, because I said to her as well that I didn't understand what was happening. After that, the second patrol police unit came. My colleague came down and we started clarifying what were the reasons of such events. And the second team of patrol policemen started saying that my vehicle blocked the road and I demonstrated that my car was at the same place, but the cars were driving along, and it was clear that my car wasn't blocking anything. The second ground was when everyone saw that other cars could drive side. The head of the deputy head of the court came down and he started recording videos and suggested to the patrol policeman to show where was the sign forbidding the car to park, and the patrol policeman couldn't demonstrate such a sign. And at that point, I got an impression that probably such events show that there were some undue interference into my activities, and I did not know why the head of the patrol police department got this reaction, and it was reflected in the Censor Net article. On Friday, I also provided the decision of the High Council of Justice. I understand that you probably haven't received it, and in that decision, the member of the High Council of Justice clearly draws attention to of the national police to the decision, and I may let me quote: "Indeed, in open access on Facebook social media, on behalf of the head of the Patrol Police Department of the National Police of Ukraine, Zhukov, on the 24th of February 2017, there was a post with a comment to the events involving Kytsyuk and employees of Patrol Police."
I don't think we have time for you to read the entire opinion. If you would just tell us where we can find it in the public record, then that will be satisfactory.
I
sent this document, I sent additional explanations, and every point, every extract has a reference, a link to this decision. Can you check?
We will look for that. But I have to say that my narrow question is whether you believe that your conduct was in accordance with judicial ethics standards during this conflict. And what I'm hearing is that your conduct may have escalated the controversy, and I don't hear you rebutting that.
Через деякий час, коли
After some time, as a result of communication with these policemen, I personally asked what was the reason of such actions to me, and the reasoning was as follows. The patrol policemen were exhausted emotionally because they were working for 2 days in a row without sleep, and so they were exhausted. As to my actions, what had to be my actions, I would like to say once again that the circumstances of that situation with unknown people accumulating around and unclear behavior of the policeman, I tried to be as restrained as possible and to avoid any conflict through my behavior. Maybe I lacked some skills of or knowledge of human psychology, but back then all the circumstances and a lot of people around who gathered very quickly made me think that something was happening, like some provocative actions or some pressure.
Okay. Now I'd like to ask you a question about your asset declaration for 2016. Your mother is listed as the owner of an apartment in the city of Kyiv with an area of 72.6 square meters and a declared value of 799,300 hryvnia. At the same time, in your declaration for 2023, your mother is listed as owning another apartment since 2019 with an area of 103 square meters with a declared value of 2,013,582 hryvnia. And this is hard to understand given that the state tax service explains that your mother's income from 2016 to 2019 was 1,320 hryvnia. Can you please inform us about how your mother could afford the first and second apartments? Also note that we asked you to provide a copy of any sale contract for the smaller apartment, and you were unable to do so.
Я надала копії договорів меншої
I have
квартири.
provided copies of the sale agreement of the smaller apartment,
Це по вулиці Заболотного і по вулиці
street Zabolotny Street,
по вулиці.
and
Справа в тому, що два договори я
well, the thing
надавала,
is that
а один
both
я
contracts
зазнала
I have provided them,
що, немає даної копії
and in
договору,
one
проте
I
ознайомившись
said that there is no copy of the contract.
яке
but after-
у Вищій кваліфікаційній комісії і окремо в
After submitting my
міжнародних
dossier that the PCIe members and HQCJ members have, this contract have been submitted and the amount stated there. How did that property, how was it acquired? Yes, indeed, she couldn't provide she couldn't provide enough money to buy that apartment. In August 2013, apartment in Kharkiv, Ludwig Svobody Avenue, that apartment was registered in my grandmother's name. I don't have a copy of this contract. I have provided my answers and an extract from the property register. And on August 13, Kaidalova, the surname of my grandmother, she's a party to that contract, and that extract cites the new owner. So the apartment was acquired, and the same month, an apartment in Kyiv was acquired. Why did my mother register it in her name? My grandmother was born in 1937, and she was unable to do the necessary operations to buy the apartment, so they decided to register the contract in my mom's name. In 2019, in November, my mother sells her car, and I also provided you the purchase and sale contract copy, and the amount is stated there. In December, she sells the apartment in Zabolotny Street, and I enclosed the copy of that contract. It was under 100,000 hryvnia. It was done with our own savings. And an apartment in Lomonosova Street was acquired. Another apartment bought in 2020. The cost to purchase that apartment, my mother received from me. I sold the apartment in Kharkiv that I inherited. There is a notary asserted gift agreement, and based on this, using this money, she bought that apartment.
So you contributed the difference between the money she had from the sale of the 72.6 square meter apartment and the 2,013,582 hryvnia. Is that what you're saying? Your mother used proceeds from the sale of the 72.6 square meter apartment, and you provided the additional money so that she could buy the 103 square meter apartment for 2 million hryvnia.
Якщо можливо, по адресам або по року,
Could
в якому
you
році?
use the address or the year when you refer to the apartments? When we talk about 2019?
Yes, in 2019, the $2 million,
19-й.
2 million
Щоб продати.
hryvnia apartment.
Щоб
You're
продати.
saying that you used your inheritance from the Kharkiv apartment, and
Yeah.
your mother used the proceeds of the sale of the 72.6 square meter apartment to be able to buy an apartment for 2 million, more than 2 million hryvnia.
Ні. У власності у матері є на
Not
сьогоднішній
exactly.
день
My mother owns
будинок
2 apartments and a house in Kirovohrad Oblast. If we are talking about the apartment purchased in 2019, the costs to purchase the apartment were received from the sale of the apartment purchased in 2013, and she also sold her car, Toyota RAV4, around 70,000 hryvnia, and the difference was covered with her own savings. My mother also has another apartment in a new building, new residential complex, and she bought it thanks to the gift agreement. That was $70,000 that I gifted her. I got this cost after I inherited the apartment in Kharkiv that I sold and then gifted the proceeds from the sale to my mother. And I would like to draw your attention to the fact that for a year and a half, the National Corruption Prevention Agency monitored my lifestyle and the compliance of my expenses and my income. Not only my income, my expenses, but also those of my family members. And my mother was subjected to this monitoring. These issues were verified quite thoroughly, and based on this monitoring, in a year and a half, in September 2025, the NAZK Corruption Prevention Agency informed me that there were no circumstances for them to act upon the monitoring results.
Thank you. And my last question is about some property that you have included in your declarations located in Bilohorkova village outside of Kyiv. And in particular, I'm interested in the construction of the 700 square meter property, a house. And my question is whether you personally incurred expenses for its construction, and if so, in what amount?
Коли я познайомилася в кінці 16-го року з теперішнім своїм чоловіком,
I met my current husband in late
точніше, його
2016.
мати була
16.
власницею
His
великої
mother
кількості земельних
wa-
ділянок
owned
Білогородка,
a lot of land in Bilohorodka village,
розпочала будівництво двох будинків.
and she started construction of two buildings, two houses there. And she had the ownership right since 2015. So she declared that, and she submitted the declarations to the appropriate bodies. If we take her declaration as of 2016, as of late 2016, this unfinished construction objects are declared, and they travel from declaration to declaration throughout years, and only the square meters change. From 200 square meters, they reached 700 square meters gradually. Regarding the expenses to provide, to guarantee construction, the number of land plots that she had in the past, in some year, the next year, the number of plots decreased, and then she declares the income from real estate. And also she declared that she alienated real estate. Before I appeared in their life, they finished construction, and in one houses I reside together with my family. My husband's mother, my mother-in-law, died. It was her dream to meet her grandchildren in one of the houses. And one of those houses, the other house, is still unfinished. Regarding my contributions to the construction, my husband's contributions, my husband took an active part in the works about this construction. Both houses were constructed in adjacent land plots. What I did, I did some land design. I planted trees, flowers, and such.
I have no further questions. Thank you.
Thank you, Mary. John has a question.
Yes, good afternoon. Do you believe that it's ever a good idea to post on Facebook or social media information regarding matters in which you presided as a judge?
Робити дописи, тут має значення, які саме дописи.
So it's about what kind of posts we do. Judge can comment on cases where they participated. Cannot comment on cases where they participated. But if there are aspects related to the case that they feel compelled to comment on them, then it can be admissible. The case that is still undergoing consideration is awaiting the final court decision. Any comments in public are banned regarding such cases.
Yes, thank you. Gabrielle, you have a further question? She's off. Okay. No, back to you, Mr. Chair.
Дякую, пане Роберте, але перед тим, як передати слово доповідачу від
you,
Вищої
Robert.
комісії суддів України, я мушу,
Before we switch to HQCJ members' questions, I need to clarify the presence of documents
Наскільки я розумію, вони є в наявності.
about which the candidate is asking for. They, PCIe, received them, right? On Friday, about 2 p.m., I sent them. Do you have the documents that the candidate provided? Mary, do you have the documents that the candidate provided on Friday?
Yeah, we have to.
Тоді не бачу сенсу розглядати ваше
Then
клопотання, оскільки
I don't see why we should consider your motion.
Вибачте, можна ще питання?
I'm sorry, could I ask another question or other clarification regarding my motion? So I've got all the declarations regarding my mother-in-law since 2016, but they're also available in the register. Her surname is Stefan. Have you submitted them in your answers? The thing is that the question, where did my husband's mother get the money, was not among questions initially, but that can be found, the answers could be found in the register. So we could actually access it during the interview. We've got this possibility. Then over to the rapporteur in this case, Member Melnik. Thank you. This possibility to ask a question. Victoria, as you gathered from the questions addressed to you by PCIe members, we are mostly concerned about events happening long before your participation in this competition, and you explained this in part. Sometimes you repeated what you have already mentioned in your written answers, but because we are holding this interview today, the key question I'm interested in, probably the rest of the audience too, when you went through qualification tests, evaluations before, did any events happen throughout this period that may testify to your non-compliance with the criteria of this competition? Throughout my professional life, I have tried to be conscientious about my professional duties and beyond the courtroom too. I know that I'm responsible as a person. I'm also responsible for a son of mine, and one of her teachers said that I am an authority for him. He knows that his mom is a public figure, and in case she affords an inappropriate conduct in public, he would be affected, so I cannot afford it. So no such events took place, no events that could make us doubt about your compliance with the criteria of this competition. I'd like to emphasize that my questions will be related to the objects stated in your declaration for 2025, and you are one of the few candidates that, before the interview, provided this declaration. Mostly, the candidates provided earlier declarations, Thank you for this. My questions will be simple regarding quite a big list of land plots that appear in your declaration for 2025 that belong to your husband, and you use them. What are those land plots? Could you explain, please? So first, I will explain why I submitted this declaration. No. So the question was a different one. It is your duty to submit declarations, and you completed this duty in a way that facilitated our study of your dossier, and that is wonderful that you provided us with this opportunity. Could you stick to the actual question? Okay, so regarding the property that appeared on my declaration is the property that was mostly inherited by my husband after his mother's death. He inherited that in 2 rounds because after his mother's death, grandmother died too, and because she had her share in the heritage, transmission rules had to be observed. So when he inherited the objects after his mother and his grandmother's deaths, and after he became the owner of those real estate objects, he decided to gift 1/3 of those objects that are located in Bilohorodka village, land plots and the house to our children with him. He also purchased 2 land plots in Kirovohrad Oblast. He benefited from electronic auction and purchased 1 land plot, and in some time another one. And one of those land plots, so it seems, was under shared ownership, and later on a contract on shared ownership was concluded. A contract about property division was concluded, and after the auction happened, he stated that in his declaration. Another real estate object is workshop facilities in Kirovohrad Oblast. So he bought that too and indicated that in his declaration. Okay, that is clear. The failure to indicate the amount of the purchase results from the heritage procedures. Is this correct? Yes. So yes, it was acquired through heritage. Then here there are no more questions. And then next topic. In your questionnaire, you stated the cases when certain protocols were registered against you. They testify to some violations, traffic violations from 2023-2024. There were 20 such cases, as you stated in your questionnaire. But we need to observe that in 10 cases, you appealed those claims, charges successfully. Could you explain why there are so many cases and how you managed to guarantee your appeals are successful? Half of the appeals are successful. As I prepared to this interview, I checked my questionnaire to make sure that among those 20 cases, 2 cases are repeated. So we have 19 cases. Out of those 19, 6 are about parking rules violations. And I agree with this, but we have a very hard time with parking in Kyiv. One of the cases was due to lack of attention a year ago, I just didn't see the parking ban to park. I started parking, and of course, it's cheaper to pay for the parking if compared to the fine. So it's not that I did that on purpose. 4 more cases in 2020, that is in 2021. I own 2 cars. One was used by my husband, the other by myself. When I got a notification about 4 fines that my husband used, we turned to the respective bodies, and we realized that these were violations fixated automatically, and that was the car that my husband used. We turned to the patrol police department, and the conclusion was made by the patrol police, and the court closed the case because there was no actual offense. And I did not appeal all the charges. I admit some violations. Despite the fact that I appeal some rulings, I still paid fines, and I did not claim my money back, even though I was entitled to the compensation. Okay, that is clear. The next question arises from the study of your questionnaire. Among recommendations provided to you by the Commission, the position of Assistant Judge Yuri Gubar of the Solominsky District Court, what kind of relationship do you maintain with him? We maintain professional relations, and I'm pleased that it's her, it's a woman. She turned to me. So she turned to me and offered that she provide me a recommendation, and I was pleased that she felt like doing it. So, of course, it's great that your subordinate takes initiative to address the Commission to share the most positive impressions of your candidacy. But do you not see some kind of conflict here? So this questionnaire is filled out by yourself, and you determined whether you should include this recommendation to your questionnaire. Do you think that recommendations from your subordinates are untypical, and it is dubious when a subordinate provides such a positive recommendation to their boss? No, I don't think that this is inappropriate or illogical, because we maintain professional relations. Right, so this is the position that you have. So did you study this issue, right? And you decided that it would be informative and constructive if you included it to your constitution. Yes, of course. All right. And among cases that you are proud of, I was interested by the following case. It was about refusing to legalize a search. The search was carried out by detectives. Could you tell us about this case? This is an untypical situation. And unfortunately, judges deny legalization rarely, and it has been a subject of professional discussions lately. What were the circumstances for you to deny legalization? So the investigating judge must abide by the law, and the main duty of the investigating judge is to maintain the rights and freedoms of individuals. In fact, there was a discussion on the matter, and the Supreme Court also announced their position. Maybe that there are too many of such searches that get legalized without proper grounds, and in that case, we need to respect the balance. When there is a need to carry out a search, or when the pretrial tries to shift responsibility onto the court and accuse them of things that they failed to do. Article 33, Part 3 determines in which cases it is possible to carry out a search without court order. Otherwise, the court must deny legalization of such a search. So in that particular case, why did you deny legalization of that search? So you mentioned the Supreme Court and other things. So it was the case that you mentioned. So Bureau of Economic Security sent motions to the court regarding legalization of searches. It pertained to gambling business, some other businesses. So there was a call to the Bureau of Economic Security. There was a report about gambling business in front of them, and they decided to carry out a search. And we need to consider the property seized. The property was just of decorative nature, and I, as a judge, I don't see much sense, utility of those proofs. So we stopped the practice of filing motions on the part of the Bureau of Economic Security. Okay, and my final question is about executive proceedings. You mentioned 9 proceedings like this.
Ці провадження в рамках справ про притягнення до відповідальності по цим штрафам патрульної поліції. Це ті випадки, де оце були скасовані 4 рішення самої патрульної поліції.
These were the cases when the 4 decisions were cancelled about the vehicle, which is my property, where the wrong model was indicated. The proceedings started, and I found out a little bit later about the ruling, and only later again the proceedings was cancelled. Thank you for the answer. I have no other questions. Colleagues, are there any other questions? May I? Do you remember the practical assignment you had to take, the one related to the false information in the declaration? You didn't apply an additional punishment, but I didn't notice the decision why it was not applied. Sorry, what decision was that? 366.2. I do not recall it. You didn't find the decision after? No. It was a questionable matter. It was about the declaration for 2023 submitted in 2024. So in your opinion, what minimum has to be indicated for what year? For 2023. But the declaration was submitted in March 2024. but it's calculated as of the 1st of January of the current year when the declaration is submitted. It's clear. And last question. The Article 366.2, you provided explanations as to the sanctions, but the disposition also changed. The legal certainty changed. What disposition had to be used? Of course, the one which alleviates what if in the past there were 500 taxable minimums and then it was changed to what version had to be applied. Depending on the situation, if the threshold is increased, it doesn't lead to a responsibility. Thank you. Serhiy Yuryevich. Ms. Viktoriia, greetings. Once again, I have a question which comes from the civil society organizations that in 2021 you signed a petition to the president to veto the law on Ukraine related to the reform of the judiciary in Ukraine, and the bodies of the judiciaries are the High Council of Justice and the HQCJ. Don't you see any conflicts here? If you have a distrust towards such bodies, wouldn't it be logical not to participate in such elections? Though today you stated that you trust the bodies, could you explain what's your perception today? And the fact that I participate in such a selection for the third time shows that I am, to the contrary, convinced that I want to be appointed as a judge in this specific court. As far as I understand, you mean the address from the Association for the Development of Judicial Self-Government. I actively participated in the activities, awareness-raising activities. We were delivering lectures at schools on justice. It was very interesting, but the years 2020 and 2021 in my life were marked by birth of two children, and it was the period when I spent much time in a hospital, and when I was still in a hospital, the question of payment of contributions were raised in the group, and I informed that I didn't see myself as part of any associations or groups at that time, and I wanted to be excluded from that association, but I didn't have time to read in the statutes how it is provided for in the statutes. I could only do that in 2023, and I wrote the request in 2023, and since then I'm no longer a member of the association, but before that I was not involved in any initiatives of the association either. So, but in the CSO's comments, it says that you signed the petition. So did you sign such petitions? No. Back then, I didn't even know about the activities of such associations, what was discussed, because I was a little bit further from the work and legal activities. So you didn't sign such documents? No. Thank you. Please, Roman. Good afternoon. About your administrative offenses, you gave the figure. You know the exact figure of 19 offenses, 6 of them were through the automatic, no, 6 were about the parking rules. Okay, what were the others? Exceeding the speed limit? I gave you the exact number because I was getting ready to such an interview, and that's why I'm giving the exact figures. So 4 of them are related to the husband. There was a violation in Solominsky district, and I paid the fine, and I and another fine was for exceeding the speed limit. It was due to automatic recording from the dash cams. I usually control what is the speed, but I failed to do so in that specific case. But I acknowledge that I'm responsible. The fine came. Other fines, I was moving along Beresteyski Avenue. Others were cancelled, no questions about that. But is there a pattern of behavior? These are different things. The 6 fines are for failure to comply with parking rules. It happens. It's wrong to say that it happens, but I spent quite a lot of time driving a vehicle. I have to drive my children everywhere, and it affects the time I spent behind a vehicle, but it's not a reason to violate traffic rules. Thank you. Okay, thank you. I may ask another question. Could you tell us, please, how do we distinguish the incitement to the unlawful benefit is distinguished with the fact of unlawful benefit? When a party selects the position of provocation, we need to rely on the fact that the funds, the money is taken, but you deny the fact of getting money, we cannot talk about provocation. Thank you for the answer. If there are no further questions, you may have the floor for 1 minute. You may inform us of the things you couldn't voice before. Thank you very much for this interview, for the atmosphere during it. It's a very pleasant. It's an honor to participate in such a selection. The fact that I am here shows that I really want that you choose me. I understand that it's a highly responsible position, being a judge of the HACC, but through my acts, through my behavior at work and in my everyday life outside of work, I prove constantly that I can be a judge of this court. Thank you very much. Thank you for participating in this interview. The interview is over. Thank you. And the list of question is